Welcome to one of the most intense courtroom moments we've seen yet. Today's case involves not one, but two back-to-back bombshell hearings. First up, Zane Buring, charged with organized criminal activity, clashing with his court-appointed attorney, and openly questioning whether he's been represented at all. Then, things escalate fast as we shift to Brian David Henry, a man facing 2 counts of continuous sexual abuse of a child. The courtroom tension is off the charts. You're about to see breakdowns, bond battles, and a judge who doesn't hold back. But what's really at stake here? We're talking child victims, disputed representation, and a possible life sentence. Stick around, because the truth? It's buried under layers of legal drama, mistrust, and high-stakes emotion. Let's break it all down.
Zane Buring, that's you? 25 CR 198. You were charged with first-degree felony engaging in organized criminal activity. And Mr. Duska is your attorney. What are we going to do on this? Where are we headed? Is this going to be disposed of, or are you going to try?
I don't know what to do, honestly. I haven't been well counseled by Mr. Duke.
How do you know that?
Because he doesn't want to do.
He's not counseling you.
He's not giving me nothing besides vague talk.
Right off the bat, we're witnessing one of the biggest sources of courtroom tension, breakdown in attorney-client communication. The defendant claims he's only getting vague advice, but the judge pushes back, explaining that lawyers advise, they don't decide. Here's a question: do you think the lawyer dropped the ball? Or is the defendant avoiding accountability? Comment below, because in legal defense, miscommunication can mean conviction.
That's what lawyers try to do. You have to make up your decisions. They give you what the options are, and what the strengths and weaknesses of the case seem to be after discovery.
I'm not getting any of that.
And you just interrupted me. I can understand why he's having a problem with you, maybe. That's kind of rude. Both of us can't speak at once. We learned that in the first grade. All right.
He's rejecting the state's offer, asking to be set on trial. I've asked the court to.
You're not able to hire somebody, are you? You're an indigent, right?
Yes, sir.
Okay. Has he filled out the indigent thing? Do you remember filling out an indigent form showing what you're?
Yes, sir.
It's not in this file. I don't have a file.
Here we go again. The court is asking for an indigent form, which determines if the defendant qualifies for a court-appointed attorney. But guess what? It's missing. It's supposed to be in the file. This moment highlights the bureaucratic chaos that often slows down justice. Missing paperwork might seem minor, but in cases like this, it can delay fair representation or worse, give grounds for appeal later.
You remember filling out something for him or with him?
I didn't too. I think it was done.
We got it. It has to.
I did it.
I'm thinking of electronic.
It didn't. A hard copy was not made. So much.
Saturdays and Sundays, just behind.
Yes, sir. It's in our electronic law.
You see it.
Yeah. Yes. He says it. Yeah. You guys class earlier. It's a class.
Copy your dad.
Didn't say.
Which one? Let's move that.
Context. When you. Yeah. After probation probated. Years. We got to call back there. Did we get?
The last time you had an income was what? What was your income?
It just varies.
What do you do? What's your profession or your occupation?
Recording engineer.
Sir?
I work in a studio, a recording studio.
Recording studio. Are you good at it? Okay, it shows like, this states your take-home pay was 2,000 a month back then, right?
Let's pause here. We've just heard that the defendant, a recording engineer, now has zero income, but previously made $2,000 a month. Why does this matter? Because his attorney is requesting a bond reduction and financial status is key in bond decisions. Here's the dilemma: should courts factor in poverty when public safety is at stake? Let us know what you think in the comments.
Now you have no income, isn't that right?
I've been in jail
Or
all
when you're in jail, you,
8 years. All
right.
So. Statuses and we're still included.
indigent, and so an attorney will be appointed to represent you. And your attorney here has been appointed, has been unable to resolve it without a trial. We're going to just set it for a trial. And Mr. Dusler is a competent lawyer. He can certainly do a good job. Are you asking the court for me to relieve him and appoint somebody else to represent you at trial?
He doesn't want to work for me.
Is that yes?
I guess so.
Okay.
I'm not aware.
But I mean, how many times have y'all spoken to each other? And then,
We smoked maybe 3 times. He doesn't want to really communicate with me at all.
all right, then I'm going to find.
Major development: the judge just relieved the defense attorney. That's rare, but not unheard of. Courts don't make that call lightly. It signals serious dysfunction between lawyer and client. But now the trial clock ticks even faster. A new attorney has to prep for a potential life-altering trial. The pressure just hit another level.
Find good cause to release him. The next person on the trial docket will be appointed to represent you. Set this for trial, and I'll see where that is. We try to get it as soon as possible. Okay. Anything else? That is all. Thank you.
I can ask a question, Your Honor? I can ask a question.
Go ahead.
So there's no way to get a bond reinstated or any of that?
Not while you keep testing positive for drugs.
Is there anywhere I can be drug tested?
Yeah. Well, we've been testing you regularly, and you keep testing positive for THC, tetrahydrocannabinol. I don't know how that's happening in the jail.
No,
And you're getting
tested
marijuana, but you're testing positive. But that's the problem, because each of positive test is a crime.
Whoa! The judge just dropped a bombshell. The defendant is still testing positive for THC while in jail. That's not just suspicious, it's criminal. This isn't about recreational use anymore. Every failed test compounds the legal risk, damaging any shot at bond. But here's a bigger question: is the system failing to control contraband? Or is the defendant gaming the system?
You're illegally possessing drugs. That weighs against you on getting a bond. You keep
I apologize.
Yeah, when you want to stop interrupting me, we'll bring you back out and we can talk. But every time you interrupt, you ruin your communication with me, sir. All right, so Mr. Buren is set for trial. Brian David Henry is called next, 25 CR 1327 and 1328. The defendant is charged in each case with the first degree felonies of continuous sexual abuse of a child under 14. If convicted in each of these enhanced first degree felonies, we're looking at no less than 25.
Yes, sir.
no less than 25 years in prison up to life imprisonment. I don't believe there's a fine on these. So it's 25 to 99 years confinement or life imprisonment. Also, the parole on this is day for day, isn't it?
That's correct.
So the minimum sentence is 25 years, and
This is not your typical felony. The judge just clarified, if convicted, the minimum sentence is 25 years served day for day. No parole. No early release. That's the kind of sentencing reserved for Texas' most serious crimes. This isn't just about punishment. It's about protecting future victims. The weight of these allegations is suffocating, and the courtroom knows it.
if sentenced to the minimum, the defendant would have to serve 25 calendar years before he would be released. So look at the thing here. These are not two separate events with the same child. These are two separate children younger than 14 years of age alleged to have been victimized, correct?
That's correct, Your Honor.
All right. Is there any other enhancements there?
I don't think so, Judge.
It's,
I'm aware of Your Honor.
it's. No,
I haven't seen any
1327
prior
looks like
history.
it alleges.
That's actually the count of the number of conduct for the continuous.
19 separate methods of committing the crime alleged in one of them. And 1327. That's what it alleges. It's what, and then the other ones. 8 allegations of criminality in 1328 of that child. Now, the defendant lived in Newton County, but these all occurred here in allegedly in Jefferson County, Texas, correct?
Yes, sir.
The age of the children, I don't see how.
16, and the other one is over the age of 18.
Couldn't have been at the time.
Not at the time.
No, I'm talking about the time of the event.
Well, that's
Do we,
Let's see.
5 for one,
6,
and 11 or 12 for
it's
the other.
allegedly December of 2015 and 1328 and
Heartbreaking moment. The court confirms the ages of the two victims, 5 and 11 years old at the time of the alleged abuse. These aren't ambiguous cases of teenage relationships. These are small children. The emotional gravity in the room changes instantly. How do you balance the presumption of innocence with the gut-wrenching horror of those numbers?
on or about December in 2016. So what would the ages be?
Years for one, and 11 or 12 for the second child,
Okay.
which is the one alleging 8 separate offenses.
The female,
Or
it's the female.
that's correct.
Okay. Today, what are we doing?
So we have a bond hearing or a bond reduction hearing scheduled for today.
Okay, stand by.
Yes, sir.
Public safety.
Safety report. A safety report. I don't think he has one.
When there's a bond here, I have to have a public safety report now, as law requires, so the court knows if there's any other criminal history, among other things, that the public safety report reports. But while we're waiting, go ahead.
Yes, sir. So I have filed a motion to reduce
The bonds are
the
what
bond.
right now?
Let's put this in perspective. the defense is asking for a $475,000 reduction from $500,000 down to $25,000. That's a massive ask in a case involving allegations of serial child abuse. The proposal includes GPS monitoring, community ties, and even a wheelchair as proof he won't flee. Would that be enough for you? Or is that simply not worth the risk?
500,000 each.
In each.
Yes, sir. In my motion, I have requested that the bond each be reduced to $25,000. Or that he be released on his own personal recognizance. And
I'll see that. Let me move back.
Keep going. I'm with you.
And Your Honor, if the court so requires, for the defendant to be released, we're asking that he be ordered to wear a GPS or global positioning system monitor tracking device. He is from Newton County. He lives and has resided in Newton County for several years, as well as Jefferson County. He has ties to the community in that he's always resided in the area. He's was currently or was employed at the time of his arrest. And there's been no evidence that he would abscond from justice or would not appear. And these are allegations, Your Honor. They have not been proven. There are a lot of factors at play here in this case that the court is unaware of.
I see.
So. Your Honor, Mr. Henry also suffers from a physical disability. As you can see, he's confined to a wheelchair because prior to his incarceration, he has to wear a leg brace.
What?
Well, he can't walk without his leg brace.
And so what's the point, though?
This might have been the most brutal rebuttal yet. When the defense points to the defendant's disability, the judge fires back, everyone has a disability of some sort. It's a stark reminder that courtroom empathy has limits, especially when children are involved. Disability does not equal defensibility. And here, it sure didn't move the needle.
I mean, everybody has a disability of some sort.
He used that as an excuse or a reason for him to be released, but clearly he has that would also hinder him from absconding if, in addition to him wearing a global tracking device.
Although the grand jury has, in its allegations, it didn't hinder him from allegedly committing two of the most serious types of crimes that the state penal code has printed and determined or punishable.
Jones.
I understand, Your Honor. Still,
These his children?
I'm sorry.
These here.
One is the biological daughter and the other is a stepdaughter.
Your Honor, may I speak?
Just a second. You've got a chance to speak here in a
Yeah.
minute. Anything else that you want to add?
Your Honor, Mr. Henry's wife is present as well in the courtroom, Jessica Morales. And she will also ensure that he makes it to court. She understands, as well as Mr. Henry, that these are very serious allegations. It's every intention of his to appear for every scheduled court date. And I believe that due to the amount of the bonds, it's unreasonably
I've seen a
high.
lot higher.
I understand the court's position on that, but and a man of his position, he's unable to make bond at those amounts. And I believe that he's entitled to a reasonable bond.
I think that's true based upon the provisions that the laws provide for, and not everybody gets a bond that they're able to afford.
And Mr. Henry doesn't have a record. He was, prior to his arrest, gainfully employed, productive citizen. And again, these are allegations, and I don't want to argue the case.
A crucial reminder here, the defense invokes presumption of innocence, a cornerstone of the legal system. But does that principle stand strong against allegations this severe? The judge doesn't deny it, but his focus remains crystal clear, protecting the public and the victims. Legal ideals meet harsh realities, and in this courtroom, reality wins.
But everybody is innocent until proven guilty.
Unless proven guilty.
Sorry. And we just believe that he should be given an opportunity to make bail so he can continue to provide for his family and go back to work.
Stay.
Judge, this is not an unusual bond for these type of offenses we've had in this court. And looking at the ages of the children at the times, the amount of actual contact he had that's alleged in our indictment.
What are the ages of the children at the time it is alleged that he sexually abused them?
But she stated, Judge, that they were, one was 11 or 12 and 10 or 11. The other one was about 5 or 6, depending on the age group, because there were several years involved.
Sir, in each of these cases, it's alleged there were multiple acts.
Yes, sir.
What quantitatively does the state understand? How many are we talking about?
Well, each one has its, as the ones we've alleged in the indictment. So we've got the 8 of the one, and I think over 12 to 15 of the other. So every one of those is an incident. So we think the bond is fair. We think for not only for the safety of the victim, safety of the public, but this man may not run normally, but this is 25 to life, and he's facing a lot of time without parole. And so we would think, just to ensure that there's no contact, no safety issues with the victims, since they were family members, that we would ask for the bond to stay at $500,000 on each one.
All right. Anything else you wanted to add?
I think that Mr. Henry would like to say something.
You want to say something, sir?
I would, Your Honor.
Hold on. Raise your right hand. As best you can. Do you solemnly swear or affirm any statements that you are about to make shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
Lower your hand. Go ahead.
If you will allow me to make bond, I'm not gonna run. I mean, if they would have called me, I'd have brought myself to them and thrown myself in. I don't run. I'm innocent. I haven't done, I did not do this.
Well, you can imagine everybody says that who's in here, and you have a presumption of innocence under the law. The grand jury, though, has deemed probable cause exists otherwise, and that's where we move from.
Okay,
The law provides that the bonds that are set are not necessarily a hearing based upon a hearing of witnesses, but based upon information that the court has. I have probable cause affidavits in each of these cases, and other information that the court has referred to. The legislature that enacted this law set forth this confinement, this punishment for each of these offenses. It is only superseded by capital murder convictions. That's the only more serious punishment range in the state of Texas for such a crime. So it has its level of seriousness, which is most high, that the legislative branch set the laws for. So, and the court bases bond hearings on a couple of things, not the least of which are the the information that the circumstances of the crime alleged and criminal histories. Those are the two major components. Here, I don't see a criminal history as a factor. Nonetheless, the seriousness of these allegations, as found, probably occurred based upon probable cause of the grand jury decision, or as we said, such a serious crime. Only more serious is capital murder, which is death penalty. So, and what we're also speaking about is that the victims are not adults; these are children. What is the price of the loss of the innocence of a child? What is the price?
Let this sink in. The judge states that only capital murder carries a more severe penalty than these charges. That's how Texas law views this type of offense. He's not being dramatic, he's quoting the penal code. In this context, asking for a massive bond reduction seems like a non-starter. The courtroom isn't just weighing fairness, it's weighing human lives.
What is the value? Anybody want to say there's something more important on this planet than that? No. That's what we're talking about, these circumstances. So, anything else you want to add? You wanted to say something?
I mean, I'll comply with whatever conditions the court sets for me. I mean, GPS tracker, whatever y'all want me to do.
How does that prevent you from harming another child if this occurred?
I did.
How would this prevent you from harming a child if you wanted to? How does the global positioning track device prevent that? It just shows where you
I don't
are.
drive.
It doesn't prevent you from committing an act.
Well, chemically castrate me. It doesn't matter. I didn't do it.
Okay. Well, that's why.
The judge makes a chilling point. How does GPS stop child harm? The defense argues that monitoring and a leg brace make the defendant low risk. But GPS tracks location, not actions. It doesn't stop a crime, it only records it afterward. It's a sobering reminder that technology can't replace accountability. Do you think GPS monitoring is enough in these cases?
We're going to have a jury trial on this, is what we want, right? On a jury trial. Let's get this moving. We'll get this moved quick enough.
Yes, sir.
Your request for a bond relief is well presented. It's denied. The court feels the circumstances of the offense as the probable cause affidavit show. Put this court in such a position. How can I guarantee a child safety under these circumstances? And yes, you're presumed innocent. I wrote the leading article on that. I'm in the state of Texas, so I believe in that. But the probable cause, but the law states circumstances of the crime through information that the court has, or is part of the equation in determining bond. And I'm going to say again, only capital murder this court finds is more serious than the allegations of two separate indictments alleging two different victims in these cases. So that compounds the problem. It's just not one. I'm looking at the public safety report here that the court is required to review. And this shows that in 1999, you were charged with illegal possession of marijuana and burglary of a habitation. What happened in those?
It was dismissed, so.
I don't know what happened. I just now heard about that.
You
When
don't.
they arrested me during my arrest.
This is under your name, under your data. It's like, it's a
So the specifics about,
supervisory caution. It says
But it would-
supervisory caution, whatever that is.
I would have to do like.
there was
well,
conviction, whatever it was disposed of.
And that's all the court is really on criminal history. If you don't have a conviction, there's not. Now, but then people could be placed on deferred or unadjudicated probation and admitted it.
It doesn't.
But that's
say
not
that
what I'm saying.
Case or.
Okay.
If, sir, somehow you were able to provide bonds in these cases, the magistrate who set these bonds originally at $500,000, I can't read the signature.
We'll show up.
But he or she provided that there will be no contact at any time of the victims. You must have a GPS device and remain in Jefferson, Orange, and or Newton counties if you were able to post a bond. So those would be required. If
This courtroom showdown ended with a hard no on bond reduction. The judge, citing the severity of the offenses, ages of the victims, and public safety, made it clear the risk is too great. We saw a defendant plead innocence, a defense argue disability, and a court stick to its legal and moral compass. The trial will move forward, and the stakes couldn't be higher. What do you think? Was the judge right to deny bond? Drop your thoughts below. And if you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.